Welcome to the Modern Equine Vets Equine Express Podcast. Host Adam Marcus talks with Dr. Charlotte Lacroix about contracts. Let's see what they have to say.
I'm delighted to be joined today by Dr. Charlotte Lacroix, who is a vet and a lawyer, and she's the owner of Veterinary Business Advisors, which is a national consulting firm that helps clients on issues involving veterinary business and legal issues. Dr. Lacroix, thank you so much for taking the time to talk.
Thank you, Adam, and I appreciate the opportunity to be on your podcast today.
So let's talk about a topic everybody loves to hate, which is non-compete clauses in contracts. The FTC issued a ruling that said non-compete clauses were not okay, and that has met some pushback. What's happened since then? And in your experience, are you seeing fewer non-compete contracts, or has the landscape not changed at all for equine veterinarians in particular?
So just a little bit of background. The reason why the FTC had this mandate was because very large companies like the Amazons, the estheticians, the coffee companies were having people sign non-competes. And what does a non-compete do? When you're looking at it from the employee's perspective, what it does is, one, it reduces their wages, right? Because if they go to the employer and say, pay me more money, the employer says no, and the employee doesn't have the freedom to just walk and work at the next store next down the street. They can only go, and they have to go further, which means they have to move their family. They have to get out of the community. That is such a burden that they're like, okay, well then I guess I won't get my raise. The other thing is it also pressures or prohibits them or doesn't to not be able to leave the place of employment. So if the employer doesn't, if they don't really like where they're working, but they really have no other choice because their children are at school, et cetera, it keeps them at that place of employment. That's what the federal government was trying to get at, was trying to give the labor force more freedom and more abilities to leave jobs and greater abilities to increase their wages. So that was the background. And anybody from Texas, you got to love Texas, because Texas is like the first state to sue the federal government. So when this came out, the FTC, the first day it came out, Texas was all over it. And so it went back from stalling this and this and this. But at the end of the day, months and months later, the ruling did not go anywhere. It was stalled. And then when we had a new administration, this is not going to go anywhere, certainly anytime soon. And even some of us in the legal community were kind of scratching our heads wondering, how does the federal government really have jurisdiction over businesses that are just within the state? They're not crossing state lines. They're not receiving funding. So we don't really understand how they get that jurisdiction. But it never came to that, certainly anyway. But behind the scenes, and you point to this, Adam, behind the scenes, what we've seen is the states, as a general rule, we're seeing a movement of now non-competes. Now, keep in mind that lawyers don't have non-competes amongst themselves. So judges probably are a little bit puzzled as to why they're there to begin with, but I'm being facetious. What we're seeing is some states void them altogether, so there's like California, North Dakota, Washington, D.C. You can't have them. Minnesota introduced a law in 2023. So what we're seeing, and California's made non-competes illegal for a very, very long time, but basically we're seeing more. Or what they're doing is non-competes can only apply to high wage earners. So like over 100,000 or 120,000. So it doesn't apply to people that are making $40,000, $60,000. Or they have, Massachusetts would be an example where they have garden leave clauses. So if you want to prevent somebody from working for a year after they cease from working, then you have to pay them that salary for a year, which you can see is quite the disincentive. Here's the reality is most, I think it's a little bit different in equine practice, but because we go to the farms and rather than the clients coming, certainly coming to you. But if the goodwill with the client is established with the practice, not with any one veterinarian, that client is likely to just stay with that practice, especially if you interchange the veterinarians that see that client. Now, I know that there's equine client. I mean, I'm a formerly equine veterinarian. I know what it's like, that will not see anybody, but I came from a larger practice and they will see other people. Sometimes when it's a particular lameness or issue, they only want to see that person. Well, that's fine. But otherwise they do establish a relationship with all the veterinarians. So I think the message to your audience is pay attention to what's going in your state. From the employer's perspective, you should still have them in your contract because you bring an associate in, you basically introduce them to your clients, you introduce them to your operations, and in the states that they're legal, you absolutely should continue putting them in your contracts. They may only be 1 year. And the geographic area should be what your zip code analysis of where 85 to 90% of your revenue comes from. And don't use a multiple of 5 because it looks like you made it up. If you have a 3 mile, a 33 mile versus a 30 mile, there's just that perception that like, where'd you come up? If somebody says 33 miles, they're like, it's not like 30 or 35 where you just made it up. But you will have to establish to a judge to say, look, 85 to 95 to 90% of my revenue comes from this. I'm not asking for more than what's in my trade area. And I think that's the exercise. It's not a hard exercise, but it's a big exercise that employers don't do, which jeopardizes the enforceability of the non-compete. And keep in mind, in order to enforce a non-compete, you got to get to a judge. Getting to a judge is a very, very expensive proposition. It can cost tens of thousands of dollars. And the employer typically has more money to put towards an attorney than an associate. And so many associates will not challenge well-written, supportable non-competes because they just can't sustain the financial battle.
So this question might sound quite naive, but are there circumstances other than desperation in which you would advise an associate to sign a non-compete agreement? In other words, and maybe are there reasonable non-compete agreements?
Well, yeah, and I represent both employers and employees, and I see both sides. And from the employer's perspective, I say, look, if your non-compete is enforceable in your state, have them because you should be protecting the business that you've invested tons and tons of time and money in, but it's got to be reasonable. You can't be asking for more than what's there. And from the associate's perspective, I explain, look, having a non-compete in this state is not an unreasonable ask because they're trying to protect the business and they don't want to bring you into their household basically only for you to like be pissed off at them and then just say, well, I'm leaving, right? And then you just set up next door. So, but again, when I counsel associates, I say, make sure, it should be based on where the revenue and that employer should demonstrate that. From an employee's perspective, generally it shouldn't be longer than a year, maybe 2 years. But here's the thing, this associate might be looking at a practice that has really good opportunities, such as training and access to some really good horses and great paraprofessional staff, and that's what's driving them working for the employer. I mean, generally, you should not make a decision based on a non-compete. That should not drive the economic decision or the employment decision unless that non-compete is so ridiculous and the employer is so calcitrant to change anything. And I also want to add that what we're seeing more of, like in the states that don't have non-competes or they're just too difficult, that you don't want to bother with them, or you want the associate and they won't sign a non-compete. I mean, all this is about negotiation leverage, right? That's what determines the outcome of most of these employment agreements. If you have well-counseled parties, but is a non-solicitation clause. So you should also have a non-solicitation of clients. You should also have a non-solicitation of employees. And there should also be a confidentiality agreement that should be properly drafted and rock solid.
Let's talk in the remaining time we have about another issue in contracts, which is retention clauses. So it seems like relative to a decade ago, you're seeing a lot more of these. Why and how are they good for, So I think we really started seeing them in corporate consolidator contracts. I think that's kind of a big one that started introducing them, and then they would be paying $5,000, $10,000, $15,000, $25,000, $150,000. It really depends on the value of that employee to the given set of circumstances. And these retention bonuses could be paid upfront. And if the employee didn't stay 1 year or the 2 years or whatever it was, they would have to reimburse the entire amount, which is not always fair because if the person dies or disabled or the employer terminates them, and many of these arrangements, the employer reserves the right to terminate the employee for no reason. And that's really potentially gaming the system, right? So you might sign on to a $50,000 signing bonus and the employer terminates you on month 11 and you have to pay back the entire $50,000. That's where we've seen a lot of them. And I think what's happening is the private practices now have to compete with that and provide these signing bonuses, these retention bonuses, which can either be given at the front, or I think,
So here's the thing. As a private practitioner, if you have to hire an attorney, it costs you money. Corporate consolidators have attorneys as employees. They can write as many as they want, to employees that are breaching a contract. So when I'm representing private employers, what I try to negotiate is try to get it so that you pay the retention bonus after the candidate has stayed the requisite period of time. So if you stay a year, I'll pay you $10,000. If you stay 2 years, I'll pay you another $20,000. Or I'll pay you $5,000, whatever it is. I mean, these signing bonuses are all over the place. It could be as little as $2,000. So you have to vet the set of circumstances in order to advise a client as to what that should be. And it talks about, what are the alternatives for the candidate? I mean, there's lots of factual things that go into deciding what the retention bonus should be. When do you go ahead and pay it? And I think the other thing that we're running into now is you see a lot of corporate consolidators, they're providing equity in their companies in exchange. So they, rather than giving them a signing bonus or retention bonus, they say, look, we'll give you $100,000 worth of equity, which is not cash, right? It's just value in stock. And you will vest over a 5-year period. The problem with those, and the reason why they're doing this is because when you give someone equity, now you have a very serious non-compete that is clearly enforceable because they're partners. They're no longer employees, and candidates have to be very, very careful signing those documents because the non-competes will often, in the equity documents, are typically broader and apply to all the practices these companies own rather than just the practice that you're working at, And the other thing is you can't get rid of the equity. You can't go to the company and say, buy my equity out even after you're vested. Because they don't have to buy it from you. You may have to wait years before there's an event. And even if there is an event, they can roll over your stock into somebody else's stock. So those are very, very tricky. But the problem with those is those non-competes are in place for as long as they own equity, which is a lot longer than an employment agreement. I mean, you could quit, but you still are bound by a non-compete indefinitely because you signed those equity documents.
So those are golden horseshoes you really want to be careful about.
Yeah. And associates don't have any money. They don't know how to read it. Like a lot of lawyers don't know how to read those 50-page documents. They're very, very specialized. You got Western, you got dressage, you got 3-day event, you got 100 jumpers. I mean, they're all horses, but the conditions that they get and the conditions you treat, they're different. And you've got to be experienced in that field if you're going to deal at the very high level. And these documents are very high level and complicated and very, very tricky. So I think what we're seeing is this, and now private practices are like, well, I want to offer equity. Well, that's a lot different thing because you don't have a platform company where you can offer, 10 shares and it be, such a very small portion, and having co-owners in a small business is a whole different aspect than companies having many, many, little shareholders.
Well, Dr. Lacroix, thank you so much for walking us through these issues. It's an interesting landscape and changing all the time. So maybe we can catch back up with you in a few months to see what, if anything, has changed.
Happy to do so. Thank you for the opportunity.